welcome you all to today's case discussion on EU Biofuel disputes, a culmination of two WTO disputes, DS600 and DS593, focused on the critical intersection of trade regulation and environmental sustainability. The European Union's Renewable Energy Directive and its implication on palm oil-based biofuels have been at the center of global discussions, leading to high-profile disputes at the WTO. Our session today brings together distinguished experts to delve into this legal, economic, and policy dimensions, exploring the balance between environmental objectives and trade practices. To start with our discussion today, I would like to invite Professor James J. Nedumpara, Head, Center for Trade and Investment Law, for his welcome remarks.
It is one of the most important WTO disputes. So, without further ado, let me invite Mr. Nitin Kumar Yadav, Additional Secretary to this committee.
Professor James, my all esteemed colleagues from CTIL, from the law faculty, all the young lawyers here who aspire to do well in the international trade laws. So it's a great opportunity for me. That's what I was telling James, that I had held the portfolio for CTIL and CW for quite some time. But during all that time, I could not get the opportunity to see the center. So I'm also grateful that you have given me this opportunity to not only be in the seminar, but also to see your center and all your bright colleagues. Also that I'm extremely grateful that you have been organizing various such seminars which are of extreme relevance, especially in today's world where we are seeing a lot of churning with regard to how the trade is operated, and while the economics of it and the commercials of it have their own challenges, the legalities are also being stretched to its limits. We have seen that in the various measures that have been announced by different countries. On one hand, we are forging new FTAs and so the multilateral body system which had evolved over a period of time, and a lot of us have been trained on the WTO and the multilateral law regime, have now to also see how plurilateral arrangements and bilateral arrangements will work, and how can we stretch our imaginations to see what we can forge in terms of our trade ties within the overall multilateral legal framework. So in that perspective, such seminars are of extreme relevance, where not only are the relations being changed and are being reoriented with different trading blocks getting formed, but also new sectors and new issues are getting, are coming to the fore. So erstwhile, while we would probably concentrate ourselves only on the trade-related matters, now the non-trade issues, whether it is economic security, whether it is environment, labor, so these issues are also getting in the forefront. And I think it is for all practitioners as well as academicians, it is an extremely relevant matter that how does one balance the legitimate rights of countries to protect their labor and environmental concerns, while also ensuring that we have a balanced and fair, non-discriminatory trade arrangements. And that for countries like ours, which is essentially a developing country, which is aspiring to be a superpower in terms of economic strength, it is extremely critical that we see that the SMDT principles that have been obtained with lot of fight and lot of struggle is not diluted, but also that one has to be practical in terms of developing our own strength and capability of not only addressing the environmental and other concerns, non-trade concerns, which has been raised by our trading partners, but also how do we design our own environmental laws and other non-trade law issues. So these not only do we handle what is being raised globally, but also how do we see that our own industries and citizens are not adversely affected by these. So I hope that the session will be very fruitful and we will come out much more enlightened. Thank you very much.
Thank you, sirs, for your introductory remarks. Now, without further ado, I invite my colleagues, Mr. Advait Rao, Mr. Samat Nair, and Mr. Anwar Singh, the three minds responsible for spearheading this event, to present us with a brief background on the case and provide their inputs on it as well. I would request the trio to start with their presentation.
This presentation covers the factual aspects, the issues which the panel was before the panel, and the panel's findings in these twin disputes on the EU's biofuel measures. There are two complaints in this case. One was brought by Indonesia in DS593 and the second by Malaysia in DS600. Disputes started in December 2019 and January 2021 respectively, and the panel reports came out in March 2024 and January 2025. Next slide. So to give the background to this dispute, the EU has the Renewable Energy Directive, and it stems right back from 1997 when a non-paper or a white paper was published by the EU Council on ensuring that renewable energies become an increasing part of the EU's energy mix. So in 1997, a non-binding target of 12% was recognized that by 2010, 12% of EU's energy mix should contain 12% of renewable energy. Then in 2003, the Pertinent Regulation Directive of 2003 was introduced, which brought in a target of renewable energy fuels in the transport sector. Because the EU's belief is that the transport sector and the fuels used in the transport sector have a direct nexus to the greenhouse gas emissions that are emitted. Then came the first RED directive, the Renewable Energy 1 directive, which brought a EU level target of 20% renewables being part of the energy mix, and also required national members of the EU to set binding targets. This target was renewed in RED 2, that by 2030, the EU's aim is that of all its energy consumption, 32% of that energy should be sourced from renewable energy. This has again recently been revised upward, that by 2030, actually the target now is 42.5%. Yes. So there are a few goals and caps that are relevant for our understanding of this dispute. The first, of course, is this 32% target, which has been revised now, which is now 42.5%, that by 2030, all the energy that the EU consumes should come, 42% of it should come from renewable sources. Next is the 14% target. In the transportation sector particularly, the EU's target is that by 2030, fuels used in the transportation sector, 14% of such fuels should be renewable fuels. Now, in this 14% target, since there is a concern that biofuels may lead indirectly to greenhouse gas emissions, a cap of 7% has been introduced, that by member states cannot have an energy mix of greater than 7% for biofuels, and if it is more than 7%, they will be not counted towards the total renewable energy mix. This cap will soon be phased out over the period of 7 years, starting from 2023 to 2030, that this 7% cap of biofuels will also be brought down to zero. Yes. Now, a pivotal concept to understand the dispute at hand is the concept of indirect land use change. Now, land can have specific purposes. It can be to grow food crop, it can be natural land, it can be plantation crops, it can also be land particularly used for the growing of crop fuels, such as rapeseed oil, such as soybean oil, such as palm oil. Now, when you have natural land, that is land with high carbon stock, that is land that helps with sequestration of carbon, that is a carbon sink, and that land is directly changed either to grow food crops or to grow oil crops. The concept there is direct land use change. However, there are instances when food crop land, that is land on which you grow crops for food consumption, makes way for land to grow oil crops. Since this trigger point then causes a shortfall in food production, there is a need to have land cleared, that is natural high carbon stock land cleared, to make way for food crops, so that your food production is not affected. Since the original trigger point is the requirement to grow land, it is the requirement of land to grow oil crops, this is known as indirect land use change. Next. Yes. So under the EU's regulations, they came out with this formula. This is just for perusal on how to determine what is the level or what is the extent of land use change caused by countries. And under this formula, you take some base rates of what was the forested land before, what is the land cleared for growing food crops, and what was the land cleared for growing oil crops. And based on this, you come with a land use change value. And based on that value, the EU has segregated oil crops or biofuels into high land use change biofuels and low land use change biofuels. Now, this is the calculation that the EU came out with, and if you look at it, there is only one biofuel or one crop oil biofuel that has been categorized as high, as causing high land use change, and that is biofuel produced by oil palm crops. Whereas all the other rapeseed, soybean, cane sugar, etc. are categorized as causing low land use change, indirect land use change. Now, this is some data which also gives further context. Currently, the transportation sector uses 7.5% of biofuels to in its renewable energy mix. The target is that this is made 14% by 2030. And the EU also imports a lot of biofuels, primarily from Malaysia as well as Indonesia, and that is why these countries being affected by the EU's measure brought this dispute. Now, Malaysia and Indonesia basically had mirrored arguments as well as mirrored issues. So we will use the complainants interchangeably. There were 4 measures at issue. It is important to note that Malaysia or Indonesia did not challenge the entirety of the RED directive itself, but certain clinical but precise aspects of it. First was this 7% share of biofuels, which they argued was arbitrary and without reason. And second was the risk classification. They argued that one, the formula which the EU used to categorize oil crops as high land use change or low land use change was arbitrary and was outdated. And the resultant being that only biofuel from palm oil was categorized as high land use change crop was challenged as being arbitrary and without scientific justification. Second was the low ILUC risk certification mechanism. This mechanism is basically a safeguard provided by EU that even if palm oil is categorized as as causing high land use change, it can be certified as low land use change crop if it is shown through a certification procedure that it has not caused the degradation or the clearing of high carbon stock land. Then fourth was a separate French national measure of a tax incentive given to biofuels. So under the French law, if you release biofuels or fuels that cause greenhouse gas emissions, you have to pay an additional tax on top of the VAT which France levies. However, certain renewable fuels are exempt from this direct measure, which will be dealt more in detail by my colleague when he takes up SEM issues. Now, coming to the actual issues that were deliberated by the panel, there were issues under 3 broad categories: TPT, GAP, and SEM. The panel first went into the TPT issues because as lex specialis, it takes predominance over general law, that is GAP, in the WTO framework. Now I invite Samar to take us through the GAP issues.
So broadly, the issues that were taking this discussion were under TPT issues, under GAT, and under the SCM agreement. I will be dealing with the TPT issue. Now broadly, when we were dealing with the TPT issue, the first question that arises is whether this particular measure or the impugned measure is a technical regulation within the TPT agreement. Now, there is a test that has been laid down by the appellate body report in the EU asbestos case, which says that if the technical regulation applies to an identifiable group of products, it lays down one or more product characteristics and whether its compliance is mandatory. Now the Malaysia and Indonesian side argued that all these three prongs apply adequately in this case. However, the European Union said that it is not part of an identifiable group of products because there is a difference with respect to land use change. It does not lay down any product characteristics, and the compliance is not mandatory because the compliance is optional if you want to pursue the certification route. And if you do not want to pursue the certification route, you can still export it into EU, but it will not count within its renewable energy targets. So the panel, when it was discussing whether this issue is a technical regulation, it saw that this palm oil is a crop-based biofuel. The end use of the crop-based biofuel, amongst others, are similar. The consumer preferences are also similar, and there is a similar tariff code assigned to all such crop-based biofuels. And therefore, it says that this particular application to palm oil biofuels is part of an identifiable group of products. Secondly, it said that it lays down one of the following product characteristics, which is production process. So when there is a discussion as to what or how you are producing palm oil, you are looking at production processes, and therefore the panel said that it fulfills the second prong of the test. Now the third prong. Here it said that this may not be an on-the-face compliance, which is a mandatory requirement, but it is a de facto requirement. It comes when you are part of the system. The certification imposes an overall regulatory scheme which has mandatory consequences, and therefore the panel said that it is a technical regulation within the WTO TBT agreement. Now, once it fulfilled the broader threshold of the definition or the ambit, then it also said that this is inconsistent with the procedural guidelines as well of publication, consultation, notice, etc. Now, moving to the second slide. Herein I will deal with three issues. The first is, how does the measure treat like products regardless of origin equally? That means it's whether there is a national treatment violation or whether there is a MFN violation. The first portion is of likeness, which was already established by the panel in the first issue, and therefore it said that there already exists a degree of similarity. Now it moved to the second prong of the argument. It said that there has been a less favorable treatment of palm oil biofuels against domestically produced biofuels, which are rapeseed and sunflower oil, and other foreign origin biofuels, which is soybean oil. So therefore, it said that that there is a less favorable treatment which is afforded to palm oils, which is because of the data that was used by the scientific assessment was not up to date. The certification procedure was too vague to be effective, and the design of this certification has a 10-year expiry period. Now this is also vague, this is also not justified. Hence it said that there is a less favorable treatment, and the last prong of de facto discrimination is established, therefore it violates Article 2.1. Now, when it was moving to the second point, is the measure scientifically justified and necessary to achieve a legitimate objective? Here, the panel first moved into analyzing what is the legitimate objective. The legitimate objective has, in quotes, composite objective of mitigating climate change, preserving biodiversity, and addressing the associated moral concerns of the EU public, which was evidence-backed. This was a 2019 EU report, which was backed by an older Globium report of 2050. Now, when the measure was looking at it, it said that this objective is legitimate in itself, and it backs it or retains it from the chapeau under Article 20. This will be further explained by my colleague as well. And it is very interesting where the panel also found that EU does not have inherent jurisdictional or territorial limitations for its own renewable energies. So the panel found that the measures are not regulating emissions outside the EU, but EU demand for crop-based biofuels inside the EU. So therefore it said that a legitimate measure, this measure for looking at environment is also directly linked with its objective, with its measure. Now, when this was being argued, a second prong was also pulled up which said that there are other alternatives which better deal with your objective. And herein they highlighted certain standards, certain schemes, certain certification programs, and this was the third prong. Is the measure in adherence with international standards? First of all, they looked at the MSPO, Malaysian Sustainable Palm Oil, RSPO, ISC, which were schemes that were developed by other organizations which were not specifically international organizations. Now the panel also went into this and said that these are not relevant organizations which take a consensus building approach to provide for standards. And then it looked at ISO standards, which were considered relevant standards to be looked at. Now they looked at 4 ISO standards. ISO standard 14040, 2016 and similar standard. While the panel was considering these 4 standards, it said that they are linked with GHG emissions, which is the broader tool, which is the broader highlight of this entire measure. But it does not deal with land use change. Now when the panel found that land use change is also a seemingly adequate objective to be followed, and the standards are not adequately linked to the land use change, therefore these standards are not applicable in this present case. Now thereafter we move to one of the last few points, one of conformity assessment procedure, which is looking at the certification scheme that is envisaged as a safeguard measure, as a safeguard to this measure where we are where EU allows other producers of palm oil to apply for a certificate stating that your particular palm oil, which you are exporting now to European Union, does not cause land use change. And herein, the first prong that was argued by Malaysia was that there is a discrimination violation, that we are treated discriminatorily. Herein, EU said that we are not treating you discriminatory. Every palm oil producer has to fulfill the conformity assessment protocol or procedure, and therefore Malaysia and Indonesia ipso facto have to fulfill it, as does Guatemala, as does other countries, and therefore it is not discriminatory. However, the certification procedure is unnecessary, and the certification procedure is an unnecessary obstacle to international trade, where it is creating complex procedures, complex designs to provide or to fall into your certification regime. So a supplier who has to apply for a certification has to fulfill certain complex criteria, wherein it has to show that this carbon stock has been there for some time, and for a long time it hasn't been deteriorated. Now this was further, the conformity assessment was further, procedure was further stated that as TBT regulation was not envisaged or was not agreed, that this was not within the WTO TBT agreement here, hence the conformity assessment procedure here is also not within the notification guidelines. Now the last portion is of Article 12, which deals with special and differential treatment. This states that there must be certain flexibility that must be afforded to developing countries by developed countries. And Malaysia and Indonesia both said that we are developing countries. We are countries where we do not have easy access to these larger green practices which are followed by Western countries, and therefore our special consideration, our special condition must be taken into consideration. Herein the EU said that the Malaysia and Indonesia development was taken into account. There were certain consultations that happened bilaterally. There were certain open EU level, at EU national level dialogues that happened. There were certain engagements that was happened with other biofuel producing countries. And therefore, there has, by doing those consultations, Malaysia and Indonesia have fulfilled their duty under Article 12. Now, there may be an argument that might have come up by Malaysia and Indonesia when they said that we may be provided certain exemptions or certain delays. Herein the panel said that no, your developing status allows you certain consultation, certain consideration, but does not provide you the right to claim exemption from a certain regulation. And therefore, your consideration of needs is an adequate satisfaction of Article 10. Thank you. Now, the measures will be challenged under that and will be led by Advait.
PPT analysis of the panel and the arguments of the parties. I will briefly take you all through the GATT analysis and the GATT issues. First, in order for the GATT was Article 11 of the GATT, 11.1 of the GATT, which requires parties to refrain from having prohibitions or restrictions on importation. On this, the argument of Malaysia was a broad-based argument that when you look at the certification procedure as low ILUC for low ILUC certification, or when you look at what happens when you classify palm oil-based biofuel as high ILUC, you're indirectly creating a cap on the amount of palm oil that can be imported into EU, which in Malaysia's view had an effect of limiting importation and therefore was in violation of Article 11.1 of the GATT. The European Union, on the other hand, told that Article 11.1 is a narrowly tailored measure and it applies only to those measures that have a directly limiting effect on importation. And this was the main bone of contention between the parties. Here, the panel deferred to the EU's arguments that yes, Article 11.1 of the GATT is a measure. It requires the standard being that it should be a measure that directly limits importation, and it could not be established by Malaysia that merely classifying biofuels from palm oil as high land use change risk could have the effect of capping their importation. Because at the end of the day, we must also be cognizant of the fact that EU's measure basically told that beyond the 7% limit or 14% limit, biofuels from palm oil or high land use change risk would not be counted. So there was no real effect of limiting importation. It would not just be counted towards the renewable energy mix. Then coming to GATT 3.4, that is national treatment, and as well as GATT 1.1, most favored nation treatment. Here, the panel, to use the term judicial economy, relied heavily on its, not judicial economy, it was panel being more time and cost effective, relied heavily on its analysis under Article of the TPT 2.1, which covers both aspects of national treatment as well as MFN treatment. The parties also made similar arguments to the ones they had furthered in their TPT arguments on 2.1, and therefore the findings of the panel on both national treatment and most favored nation treatment was in favor of the complainants, Indonesia and Malaysia. First, the panel agreed that similar to what it had held under the TPT analysis, that palm oil derived biofuels derived either from palm oil or rapeseed oil or soybean oil were like products because there was no distinction, there was no difference in end use, they had the same HS classification, etc. And the effect of the red regulation as well as the other measures at issue was that it put palm oil based biofuel at a disadvantageous position. And the same was also for under Article 1. That this violated the most favored nation treatment because palm oil from Indonesia and Malaysia faced de facto discrimination because they were large palm oil producing nations, and the palm oil that came from these two countries would not be counted towards the energy mix after a certain cap. Then came Article 10.3 of the GATT, which requires a reasonable and impartial administration of regulations. Article 10 of the GATT is broadly a transparency article, which is increasingly being incorporated in FTAs also. And Article 10.3a requires that regulations of a party or of a member are applied in a manner that is reasonable, impartial, and not arbitrary. Here, Malaysia's argument was that the directing regulation, that is the delegated directing regulation, was administrative in nature because it provided the means to calculate what is low indirect land use change crop, and that was the basis for providing certification. The EU, on the other hand, argued that no, we actually do not have an implementing regulation. The delegated regulation is just a means to calculate and what would be required to provide the rules on how you would get low ILUC certification. Here again, the panel told that the implementing regulation was actually administrative in nature, and since it was vague, it was not administered in an impartial manner. It again found in favor of the complainants, Malaysia and Indonesia. Coming now that the inconsistency with GATT 3, with GATT 1 and GATT 10.3 was established, it was for EU to claim an affirmative defense or invoke Article 20 of the GATT, which deals with general exceptions, and is one where there is significant jurisprudence, and this case in particular gives interesting points to consider. Under Article 20, the analysis is a reverse analysis, a two-tiered analysis. First, the panels have to look into whether the responding party has successfully claimed a legitimate measure under one of the sub-paragraphs of Article 20B. Once that is successfully established, it is provisionally met. The test is provisionally met. The second tier of this test is that the chapeau of Article 20 should be met. The panel, EU claims, etc., is an issue of morality for the EU public, and parliamentarians also, they adduce statements made by certain EU parliamentarians, certain French parliament. The argument they made was on subparagraph B and subparagraph G that relates to human protection of human, animal or plant life or health, and for the conservation of exhaustible natural resources. The EU's argument was that climate change is a pressing concern for humanity as a whole, and EU also is suffering from the effects of climate change, and it also adduced previous panel judgments and appellate body reports which recognize that there can be measures that can be taken to protect the environment, because animal, plant life or health and human life or health together can be seen to be part of the environment. And on G, the argument was that exhaustible natural resources, as in to protect climate change, is also to further the conservation of exhaustible natural resources such as high carbon stock land, as these are carbon sinks, as I had told in my introductory remarks. On B and G, the panel found in favor of E that yes, there is sufficient jurisdictional nexus between the measure taken, that is RED 2, and the goal of climate change mitigation. And this has important implications, but because the panel in doing so also held that if there is an extraterritorial effect on because of your regulation taken in furtherance of climate change, that could still be justified under the sub-paragraphs of Article 20. This has implications for EU's other regulations, which I'm sure the panelists will take up. And so on subparagraph B and subparagraph G, the panel found that the EU had provisionally justified its measure. On subparagraph A, the panel exercised judicial economy and held that since it has found in EU's favor in B and G, finding in its favor in A would not really materially affect the outcome of the dispute, and therefore it did not go into the issue of analysis of public model exception and left it open to future panels to decide. Now that the subparagraphs were established, the panel had to look into the chapeau test, which requires that a measure in furtherance of the general exception not be applied in an arbitrary or discriminatory manner or as a disguised restriction on international trade. Here, again, it is where the EU faltered and could not successfully defend its claim, because the panel found in favor of Malaysia and Indonesia and said that the directive, since it was not based on updated standards, updated data, as well as since the calculation of reaching the determination of crop as high land use change was arbitrary and had caused discrimination against biofuels being imported from Malaysia and Indonesia. And there was also a dissenting opinion which will be dealt with by my colleague Anmol, where the dissenting panelists also characterized the EU's measure as a protectionist measure. Since the chapeau test was not met, the EU was not successful in invoking the defense under general exceptions, and therefore the GATT inconsistencies stay as the panel found them. This leads me to the SCM issues, which will be dealt with by my colleague Anwar.
Claims under this dispute was raised by the complainants Malaysia and Indonesia and DS600 and DS593 respectively, was regarding the French measure derived. It contended that derived was an illegal subsidy under the SCM agreement, and for a measure to be considered as a subsidy, it must meet two conditions. First of all, it should be a financial contribution given by the government, and as a result, a benefit must be conferred. Malaysia's claim rested on two alternative arguments as to what constituted a financial contribution. Its primary argument was that there was a government revenue which was foregone. It said that the French government had a tax in place and on fuels, and then it gave tax break to certain qualifying biofuels, and as a result, it had foregone the revenue that it would have otherwise collected. the EU responded to this and said that there was no revenue which was foregone because the tariff was a measure wherein there was a tax rate which was given on the basis of biofuel incorporation. Malaysia proposed a normative benchmark. It said that the maximum tax rate payable under the tariff was the normative benchmark against which the tax break should be measured. Whereas EU said that the normative benchmark would be entire tariff as a whole and not the maximum tax rate. The panel had to determine the correct normative benchmark to see if the revenue was indeed foregone. Out of the proposed normative benchmarks by Malaysia and the EU, the panel ultimately agreed with the EU. It found that the most appropriate benchmark was tariff formula as a whole. And because the benchmark and the challenged treatment are one and the same, there was no revenue which was foregone, and as a result, the panel found that there was no financial contribution under the SCM agreement. Malaysia also made an alternative argument. It said that the tariff measure was a form of income support. This income support was for qualifying biofuels, which allowed them to lower their prices and as a result increase their market share. EU responded that tariff does not support income. It does not lower the production cost for biofuels, rather it incentivizes the use of higher cost biofuels. EU also said that tariff is a behavioral tax designed to achieve certain environmental goals. And since the term income support has not been previously interpreted in disputes, the panel looked at a related term of price support. It determined that income support implies direct government intervention to maintain income at a particular level. The panel found that tariff does not operate in this way and therefore concluded that Malaysia failed to establish that the French tariff constitutes income support. And since one of the two essential elements of subsidy was not fulfilled, no subsidy was found in this case. However, the panel conducted a further analysis assuming arguendo, that is for the sake of argument, that a financial contribution did exist based on Malaysia's proposed benchmark. Based on this assumption, the panel found that a benefit would be conferred on fuel suppliers as they are paying less taxes than they otherwise would have. The panel also found that the subsidy would be specific because the access to lower tax rate is explicitly limited to a certain group of enterprises, that is those that incorporate qualifying biofuels, and the criteria for this eligibility is not objective. To win, Malaysia also had to prove that the subsidy caused serious prejudice to its interests, such as displacing imports or causing lost sales. The panel conducted a counterfactual analysis asking what the market would look like without the subsidy. The panel concluded that without the tariff, there would be no commercial market for biofuels in France, as they are not price competitive to fossil fuels. Therefore, the absence of subsidy would not help Malaysia and Indonesia. Rather, it would eliminate the entire biofuel market, and hence the panel found that there was no causal link between the subsidy and the alleged harm. And therefore, because there was no financial contribution found, the panel said that there was no subsidy, and even if had there been a financial contribution in place, the complainants, Malaysia and Indonesia, failed to establish that it caused adverse effects to its interests. The claims brought by Indonesia in DS593 are identical to the claims brought by Malaysia in DS600. However, there is an additional claim which Indonesia raised in DS593, and that claim was regarding import substitution subsidy. Indonesia claimed that tariff was a prohibited import substitution subsidy However, this claim was also rejected by the panel. It found that the legal standard for a prohibited subsidy requires strict condition or requirement to use domestic goods to get a subsidy. The panel found that the other qualifying biofuels like soybean-based biofuels are also imported into France, and these imported biofuels are eligible for tax reductions. And therefore, subsidy was not contingent on use of domestic goods over imported goods. Rather, it was dependent on using qualifying biofuels over non-qualifying biofuels. And as a result, Indonesia also failed to prove its claim. While the official panel found EU's administration of these rules to be discriminatory in certain aspects, a strong dissenting opinion argued that this measure was fundamentally flawed. The separate opinion highlights evidence that EU's objective was not purely environmental, but also included an element of protectionism to favor its own domestic oils like rapeseed oil. The dissenter concluded that singling out palm oil was arbitrary, as other crops like soybean appeared to pose a similar, if not greater, environmental risk, making the measure an unjustifiable and disguised restriction on trade. Thank you.
Speakers, Shri Nitin Kumar Yadav, Additional Secretary from Department of Commerce, Government of India, Sadat, Senior Assistant Professor at Indian Society of International Law, Ms. Shri Pradeep, Associate Assistant Professor at Center for Trade and Investment Law, and Mr. Vishishth Malhotra, Associate at Center for Trade and Investment Law. Their insights will help us better understand the nuances of these cases and their potential implications for sustainable trade governance. I would now request the chair of the panel, Shri Nitin Kumar Yadav, to take it forward.
Thank you. Thank you for a wonderful presentation, briefing the whole issue, how it was taken up, and what was the different insights that went into the panel's orders. So I think it also throws a light if the discussions can happen in two parts. One is, of course, the actual the particular case, the nuances of the case in terms of that while the overall principles was upheld by the WTO panel, that legitimate environmental concerns can be taken up by the members of the WTO, but also those implications, even if they are extraterritorial, would be legitimate. Okay, they can be imposed. So this is our overarching principle, and that would probably also have implication of CBAM, EUDR, and other similar regulations and laws which are coming in place. We also see that the main concerns came from the procedural part in terms of its implementation. While the objective may be legitimate, how they are implemented, so the devil lies in the details. And and it often happens that in the garb of very legitimate and very noble sounding objectives, measures are introduced which are extremely discriminatory, non-transparent. They are introduced in a very non-transparent manner. A very cursory kind of consultations are done, and those consultations are how would they be incorporated in the decision making is not clear. So those transparency issues are also to be thrashed out. Second part would be then when the data collection is an important part. So for example, if you say that the land use change has these implications, the formula that was introduced was challenged. And so you may say that yes, some measure causes environmental loss or degradation, but how do you calculate that? Is there a scientific study? Is it acceptable? So those part, so that formula or the formulation in which it will be measured is an important part. Do we propose something in which it is accepted at a larger level rather than unilaterally by a country, saying that my law says this is the formula, you have to implement it, when the implications are much more global, both in terms of the climate impact as well as the trade. So both the objective and the implications are global in nature, but are being formulated unilaterally by, say, EU or a specific country. Then further, one would so even if the formula is also based on a sound scientific study, the data collection to implement that formula is also something which needs to be looked into. So one can always there is always a big discrimination or difference in the quality of data that are procured or that are obtained in different parts of the globe. So while some countries maintain a very thorough database of what was the baseline, so the UDR, for example, will have this issue of what was the forest thing at the base. So how will you base it on the satellite imagery? Satellite imageries are also not common of same accuracy everywhere. Is satellite imagery enough? So the data collection itself may lead to discrimination in how it is implemented. So if the discussions can also happen, this is a specific case issue in point, that if supposedly legitimate climate control or climate mitigation issue law is introduced, how it is implemented. And second part would be that how would these be then used if it is not properly used? Can this instrument be used for other measures, whether it is labor, whether it's bringing into different sectors? And there is a difference in how developed and developing and under LDCs handle these non-economic issues. While we have to see the history, London used to be the most polluted city in 100 years back. So now, so Europe does realize in its civil society areas that we have just transferred our pollution to lesser developed countries, but they are still the largest consumers of these resource-intensive commodities, for which the developing countries are essentially sourcing them. So how do you delineate yourself, saying that I am the moral obligation, as was mentioned here, those products which use those resources? So these are the broad questions that one can say that comes to my mind. And I'm sure it will be much more enlightening. Thank you.
Presentation. So if you really look at this measure, this is actually a textbook case. So we have got a regulatory measure by the European Union, which is, as the additional secretary mentioned, is an extraterritorial measure. Is it what? So it has got a regulatory aspect, then it is also a fiscal measure. And that is the point which Anwar mentioned, especially the French measure, the TTIP measure is actually a tax incentive, so it has got an esteemed component as well. Then we know that this measure is, according to the European Union, an environmental measure. And therefore, it is actually a climate change measure. And the next point is that this element also has got some kind of a quantitative restriction. Because one of the challenge aspects of the measure is basically the 7% limitation. So what the European Union has actually done is the renewable energy mix from biofuel will have to be 7%. So it cannot actually go beyond that 7%, which is a kind of a quantitative restriction. Then this measure also has got a moral concern. The moral concern is actually from the perspective of the European consumer, who wants to have a very low threshold of carbon emissions or maybe reduction of greenhouse gases. Then this measure has got various elements with respect to transmission. So you can say that it is actually an origin neutral measure. When you read the RED 2 measure or even the predecessor measure, the RED 1 measure, the measure does not express on the face of it actually mention any particular jurisdiction which could be a potential target of the measure. But when you really look at the subsequent implementing measures, so you have got the RED 2, and within RED 2 there is an article which is called Article 26, which is basically the substantive provision within the regulation, which actually has got trade effects or trade implications. Then the way the measure has been implemented is through an implementing regulation of the European Union, which is the directive. And the directive also provides the mechanism in order to provide a list of countries or a list of products which can actually qualify as being treated as a biofuel or a bioliquid or a biomass, from which the European Union renewable energy target can basically implement. So then, of course, if you really look at, when you really look at this measure has a very long history, starting from 2009 onwards. The first is actually a red one. Then you have got the European Parliament actually coming in with a report. The European Parliament even taking a decision way back in 2017 that biofuel from palm oil should be completely phased out. So what they said is that the presence of biofuel in the European Union transport market should be zero. So it is actually a complete quantitative restriction on the mix, on the share of biofuel from palm oil in the European Union. So what the European Union Council did was to basically tone down some of the recommendations of the European Parliament amendment proposal and then put this measure into operation. So when you really look at this measure, as I mentioned, I think this point has been mentioned by multiple people, in fact, by the additional secretary as well. The nature of analysis involved in the decision as well as the kind of argumentation made in the measure provides a preview of a potential challenge of a deforestation regulation or even the European Union CBAM regulation for that matter. The first thing, as Anwar mentioned, this is actually a technical regulation. So substantively, if you really look at the nature of discussion or the argumentation made in this dispute, the bulk of the dispute is basically centering around Article 2.1 of the TBT agreement. And then they mentioned that, not for judicial economy purposes, but they said that for the purpose of repetition, we don't have to actually repeat this argument when it comes to Article 1.1 or 3.4 or even Article 20 of the GATT. So I will actually look at this measure from a TBT point of view. So one important issue is that this measure is also in a way a PP, a non-product related process production method. So when you really look at the nature of biofuel that is coming into the European market, you can actually make a distinction between biofuel based upon the particular source. So you can say that, at least in terms of physical characteristics, there isn't much of a difference, but it is based upon an externality. The externality is that when there is actually a greater demand in the European Union for a higher renewable energy mix, especially as part of the European green energy policy and also part of the European Union transport policy, which actually provides a maximum ceiling of 14%, there has to be net greenhouse gas savings. So what we are saying is that when we are coming up with this particular policy, we have to make sure that there is a net saving, greenhouse gas saving. So the other argument is that, of course, we have got definite set of an arable land, and the three important sources of fuel, which is actually the source of fuel which is basically used in the transportation sector is one is rapeseed oil, the second is soybean, and the third is sunflower oil. And within the European Union, all these categories of biofuel, you can say biofuel is basically produced. When it comes to certain other countries, maybe you can actually look at Brazil for that matter. Brazil exports a huge amount of soybean-based biofuel, or maybe even sugar-based biofuel. And these categories of biofuel are actually qualifying what we call as, they are actually qualifying the description of low indirect land use change description. So only this particular palm oil is being singled out. And according to the European Union, there is a particular reason as to why palm oil is being singled out. We are not actually doing it based on any kind of a protectionist intent, but there is actually some kind of a scientific evidence. And this is something very interesting as well. So what the European Union has done, they have actually done this particular exercise based upon some kind of a calculation, a formula. The formula has a particular, a 10% thing. So the point is that if there is an advancement of cultivation into area which is basically carbon sink area, high carbon sink area, then we will actually determine that particular feed to be a high ILU risk category. So how will it determine that thing? Maybe they can actually, they can go for geomapping, they can use scientific methods. But what Indonesia and Malaysia argued in this particular case is that in terms of the absolute contribution, it is not actually most important. If you really look at the composition of biofuels, soybean, then sugar-based, then of course rapeseed-based and the sunflower-based actually constitute the bulkiest share. The one from palm oil is not actually the most important one. But in terms of relative increase, and they have actually put that percentage at 10%. So if the annual increase is actually 10%, then you will qualify as a high indirect land use change contributing on. So you can say that particular method, that determination is actually done on a global basis. So you can say that every country will come out with a regulation based upon the situation prevailing in their country, and they will do everything possible not to hurt their own sectors. So naturally, they haven't done anything in order to hurt soybean or rapeseed or sunflower in the European Union. But then why palm oil? But there are some indications actually that palm oil, because of the presence of Indonesia and Malaysia in the tropical region, most of the dense forests are actually located in that area. So the point is that two categories of risk can emanate. One is actually the direct land use change, and the second is the indirect land use change. So when there is a greater demand for renewable energy or biofuel-based renewable energy in the transportation sector or within the economy in the European Union, it will lead to a direct or maybe higher demand in biofuel. But the second thing is that they have actually put a phase out. So the most important thing in this particular case is actually the cap and the phase out. The 7% is not a major issue. I don't think that any country has raised that issue, and the panel itself mentions the point that 7% is not actually a contestable matter. So the real issue is actually the cap and the phase out period. So the point is that now they have got a cap and they have got a phase out. So it cannot be used going forward, and it will be completely phased out by 2030. So that means from an Article 2.1 of the TBT agreement, the most important thing in the exam is actually the detrimental effect. So I'm going to completely ignore, the traditional analysis, which is actually based upon the physical characteristics of the product. There is not much dispute on that particular point. Then you look at the end use of the product concerned, and it is absolutely natural that when someone is going to fill his vehicle with fuel, they won't actually look at whether it is coming from soybean or maybe from rapeseed oil or maybe palm oil for that matter. So there is very little commercial interchangeability. I mean, there's complete interchangeability, I would say. And the end use is basically the same thing. So on these issues, there is absolutely no doubt. With respect to tariff classification, again, the product comes in the same category. The only interesting issue which I was actually looking at the panel report with some interest was actually in the consumer perceptions. So if you really look at this report is actually, you can say, a redux of the EC asbestos case. In the EC asbestos case as well, they were actually put a ban on chrysotile fiber asbestos when the PCG fiber was permitted within the European Union. So and the panel actually said that it is a GATT issue and not a TBT measure. The appellate body said the correct way of interpretation or analysis should have been the TBT agreement first and then the GATT. But in the like product determination in the asbestos case, they actually brought in the risk factor. So if the consumers consider this particular product to pose risks to certain categories or values, maybe an environmental concern or a health concern, that particular factor can be used in order to distinguish the products, even if they are similar with respect to all of the categories. The panel does not pay any, the panel does not actually pay much attention to the consumer perception argument, but at least I feel that some more discussion or analysis could have been done by the panel on this point. Then again, the interesting point, I think this is something which I examine as well. There is a detrimental impact, which is very clear. So, the appellate body then created in the pro-cigarette case a very interesting analysis whether if this detrimental impact is actually stemming exclusively from a legitimate regulatory concern, then the measure will be considered with GATT compatible. So TBT compatible. The problem is that the TBT agreement may be either deliberately or, I don't know, by accident, does not have an exception. So if a measure is actually, if a TBT measure is a violation of the non-discrimination principle, especially the national treatment or the MFN treatment, then that is it. The country cannot actually use a GATT Article 20 type exception for it. So in a very important court craft, the appellate body created that legitimate regulatory distinction. And how that is actually, so the point is that if when you read the panel report, the panel says that the way they are actually making a distinction between palm oil based biofuel and other categories of biofuel is actually based on a legitimate concern, legitimate distinction. So that distinction is actually legitimate. And as the additional secretary mentioned, the point is that, so they said that what you have done is absolutely fine. The European Union has come out with a regulation which has made a distinction between this oil and the palm oil and all other categories of oil, six other categories of oil based on a legitimate regulatory objective. Then they examined this issue. But still there are some problems with respect to this measure. And as Anwar mentioned, only on 2 points they actually found some kind of a problem with this approach. One is actually with respect to the collection of data. So when you collect data in order to make a scientific assessment, it should be based on a contemporaneous data or the most updated data. So they actually did this calculation on the basis of historical data. So only the choice of the data actually made the difference. The second is that the palm oil is actually a perennial kind of a crop. So the point is that the normal life of a palm oil tree is 17 years, and it starts harvesting from the 7th year onwards. And so they had got an additionality requirement which actually against singled out palm oil, whereas in the case of rapeseed or soybean, it is actually replaceable on an annual basis. So the point is that if you can actually make productivity gains, then the productivity gains can also mitigate the impact of this particular regulation. That benefit was given to all of the categories of biofuel, but not to palm oil. So again, only on 2 very small categories, very small. I think I would actually say only on 2 minor design flaws of the measure, the panel said that it is actually violative of the Article 2.1 of the TBT. But again, they said that on Article 2.2, this particular measure is actually meeting all the environmental or other objectives, and if these objectives are not actually fulfilled, there are risks. So on Article 2.2 of the TBT agreement, the panel actually sides with the European Union. But when you read this report, you actually get an impression that Malaysia has lost the case and Indonesia has lost the case on Article 1.1 of the GATT, 2.1 of the TBT, numerous provisions of the TBT agreement and other things. But in reality, the European Union has actually come out victorious. And the last point again, which is very important, the point is when you come up with even deforestation measures, right? Europe doesn't have any forest birth in A, whereas all the tropical forests are actually in this particular region, Indonesia, Malaysia, Brazil for that matter. Any kind of a climate change measure will disproportionately impact these countries. So, it is one way it is possible to argue that if the nature of the measure is going to have extraterritorial impact, then you should try to mitigate the risk involved. So you have to actually iron out the differences. And for students of international, I would also like to mention one particular case called the US shrimp case. So in the US shrimp case, the WHO appellate body said that when you come out with a measure which can have an extraterritorial impact, you can't actually come out with a measure in a rigid and unbending manner. And most importantly, you have to take into account the situation prevailing in the concerned countries. So not every country may have the same kind of a regulatory structure, but you have to be mindful of the regulatory system prevailing in a country. So in that case, they were actually talking about the impact of the measure with respect to shrimp harvesting. But think about a situation. If you really look at this measure from a regulatory point of view, Malaysia can still ensure, or maybe Indonesia can ensure that the palm oil that is exported to the European Union is not actually coming from a land which was earlier part of a biomass, a carbon, sink or carbon steel. They can make sure that this product is not actually coming from that converted land. So the concern is actually from the progression of land, right? The conversion of land, not only land, carbon intensive land for agricultural purposes, and that is what they refer to as the indirect land use change. But if the exporter can show that my product, my biofuel is coming from an area which was previously harvested, previously arable land, and not converted from a forest, then I should be getting the benefit of through a TBD, through a certification mechanism. So the law ILUC certification mechanism, again, I think they did it in such a manner that Malaysia cannot use that. So again, I think so. I'm not completely surprised that there is actually a dissenting report. But the dissenting report is actually more of a policy statement than a clear articulation of arguments. So I will stop here, but my feeling is that somehow there is no reference to CBD or RC. I think anyone who talks about CBD or RC should say that in WTO dispute settlement it will not apply. Because there has to be an opportunity to discuss in the context of Article 20. So where can it really fit in? I think this measure in all likelihood will be taken up under Article 2.1 of the TBT agreement. They will only try to find out whether this actually, this will based upon a legitimate regulatory distinction. And one major area, from a jurisprudential point of view, one major concern here is that the panel is trying to construct some kind of a parallelism between the analysis in TBT agreement and the GATT. The TBT agreement and the GATT, maybe there are design flaws. The approach they have followed in Article 2.1 of the TBT agreement is actually used in the same way in Article 3.4 of the GATT and other provisions. Article 3.4 of the GATT, including the Article 20 analysis. So what you see in this particular case is actually a complete truncated analysis of Article 20. There is not even a proper analysis in the SHOPO. The only kind of discussion of the extraterritorial impact to an extent is actually in the discussion with respect to Article 20G. And one more important point which actually struck me, generally speaking, if it is a health measure, then the necessity examination is very important, right? So in the case of necessity examination, the Malaysian side also came with alternative measures which they don't examine properly. But my feeling is that if this kind of an approach is taken to the panels in the future, even the existence of an alternative measure which can actually satisfy the same regulatory objectives will not be taken away. So these are some of the larger issues which I thought may be important from the point of view of this particular topic.
Other colleagues, I'm not a trained law expert, specialized in international environmental, but I will reflect on this case from international environmental law perspective, from climate change. That is equally important. So after reading this case, I was drawn to one principle in Stockholm Declaration, Principle 23, which clearly says that a nation which is taking environmental measures, they have to take into consideration unwarranted social cost it will have on developing countries. They will have to take into consideration their stage of development. They have to take into consideration whether they will be able to cope with this or not. So, if you read Article 2.3 of TBT, just mentioned that you can draw a parallel. So, a lot of people suppose are getting unemployed, losing job as a result of these measures, because this palm oil is one of the regions of prosperity in Malaysia and Indonesia. I have gone through the rural livelihood is dependent on palm oil in Malaysia and Indonesia. So, if you read climate change regime, you find there is an argument just transition. If a lot of people are going to become unemployed as a result of shutting down of greenhouse gas intensive industries and other industries, isn't it? So how you will rehabilitate them? Their dignified living is at stake. And if you read ILO declaration, International Labour Organization's guidelines, that says that they all have to be rehabilitated in a dignified manner, isn't it? this is a major concern. India has raised it in climate change. So this issue, this lot of people losing job as a result of that, I view it is directly linked to just transition, isn't it? And it is at this stage that just transition is considered to be that it will be covering only those people, those labor men, working men who are involved in fossil fuel industries, not this, not agriculture, isn't it? So that's why they might not figure. But definitely those countries who will be bearing this kind of brunt, they will raise the issue in the climate change negotiation that what about their fate? What about the fate of our agriculturalists, those people? Isn't it? And it is also that the equity, that the common but differentiated responsibility you talk about, and in fact it is our loss. You talk about that the CBDR has to be national circumstances. So we have a right to determine our contribution to climate change mitigation, nationally determined contribution. It says nationally determined. We have to decide. We have to find in our given circumstances how we can contribute to mitigation.
Sir, can I interrupt you? I think the students can't hear you. It has to be closer to your.
Choose that there is now there are a number of judicial pronouncements, many in domestic situations at international level, International Tribunal for the Law of the Sea, International Court of Justice advisory opinion, isn't it? They all insist on due diligence obligations of all countries, including developing countries, isn't it? Now, due diligence, you have to act also diligently. You have to act also diligently. It amounts to saying that, does it amount to saying that we have to stop all those things which result in development but which also result in emission? This is a very serious question that it is ICJ advisory opinion delivered yesterday. It has not been able to address that aspect. But of course it has insisted that it includes that not to cause transboundary harm. It also means not to cause climate change also system, isn't it? So this is the some of the yeah. So now in this case, EU Biofuel case, panel has provisionally held, isn't it? Article 20B and G and 20G to conservation of exhaustible natural resources. Yes. Conservation of exhaustible natural resources. Yeah. There is one interpretation that is I read in some of the domestic climate change litigation. This argument is coming up that the conservation of exhaustible natural resources means that this atmosphere has limited capacity to absorb further carbon. To absorb further carbon, it is limited. It is not unlimited. So it cannot absorb further carbon. So this argument is getting favor. Climate stakeholders, they are saying that the activists, they are saying that no, this is atmospheric resource comes within the purview of, it is a public trust also. Atmospheric trust litigation, there is a case called Juliana case. In that day, it is this argument, this plea is being taken that it is a public trust and all the countries have to take into consideration that they have to put some limitations on the emissions of greenhouse gases. So exhaustible, this conservation of exhaustible natural resources. I think my learned friend James will enlighten on this, that the James Shrimp turtle case, appellate body said that the conservation of exhaustible natural resource is crafted 50 years ago, so it cannot remain static. you have to interpret in light of contemporary circumstances concerns, isn't it? Contemporary concerns, contemporary circumstances. Can we say that the climate change it poses existential threat to mankind? So conservation of exhaustible natural resource, we should think about our atmosphere, which poses existential threat to mankind, isn't it? So it is this argument is gaining ground, this conservation of natural, this exhaustible natural. Another that I was reading Brazil retreated tire case also in that they, and I found that the climate change angle is there, circular economy, and it is saying that the immediate risk to public health does not mean that it has to come immediately. It may come after some time also, 20 years, 30 years, isn't it? So the public health angle, if some of the countries are saying that I have public health angle, isn't it? So it looks like that the climate change is what I see from the judgments from the ICLOS, ICJ, or many other, in fact, international, Inter-American Court of Human Rights also, if you read the judgment. There are other judgments also. There are many, I can cite along with 50, 100 judgments, that there is an effort, that there is effort of what you say, systemic interpretation, we say in international law, systemic interpretation, that the Vienna Convention of Law of Treaties, there is an article 31, para 1, 3, and systematic interpretation, systemic interpretation, that other areas, other considerations, other rules are being taken into account to produce a harmonious, harmonious construct. In this case also, if you read ICJ advisory opinion delivered on 23rd, that international trade law, human rights law, other laws were put into consider then this thing that they know. So climate change has pervasive influence, I can say. In this case also, I see that this angle, but of course, that international community will have to take into consideration the concerns of developing countries, those who are going to. It is not that the small island states are going to be wiped out, but what about those people who will die from hunger, malnutrition, if they lose job, if they become unemployed, their livelihood is at stake. So these are the concerns which need to be addressed with equal force as compared to what European Union is. They are mastering in their approach. They have that there are several things. I am raising it just to, if one of our students or researchers who are sitting here, they can inform and enlighten me also that my learned friend James can also, that France has introduced a measure that is called ecologic bonus in case of electric vehicles, and in there they have put that electric vehicles, those which have been produced, and they have put a ceiling 14.79. Just see.
What would it be?
14.75 tons of CO2. Carbon production, carbon footprint ceiling, isn't it? So if they do more, then they will not get subsidy. Actually, China was dominating their market in electric vehicles. France did it, and then they are getting benefit of it. Because when I'm painting in broad brush, though there are some objectivity in my arguments simultaneously, that this carbon footprint and this article is that it can be challenged. It can be challenged. So I see that after my reading that of course reconciling competing objectives is always challenging. That the climate, environment, development, and you have to do a lot of pros and cons. You have to weigh those arguments, and then we have to be. It's definitely very challenging. We are at a very crucial juncture that we need the support of all the countries on the board. Thank you very much.
Thank you, Dr. Sadat. Good afternoon. Some of the legal issues that the case raises. So in my intervention, I would be making my comments in three parts. So one is the general observations and what kind of notions does the case dispel or does not dispel with respect to what countries can do in terms of regulatory space for environment and environmental concerns, of course. The second is, of course, the legal provisions and the nuances and where the panel fell short of meeting a specific standard or where there is lack of clarity, as Professor James also pointed out, with respect to specific concerns that perhaps are not appropriately placed under WTO law, but to some extent could have been clarified in terms of policy objectives that countries can pursue. And the third is with respect to the striking similarities and differences the case offers for other EU regulations and potential regulatory space that countries will exercise in future on these causes. So to begin with, in terms of general observations, I think one important fact that one needs to note when examining and reading this case is the specific objective of the RED 2 regulation itself. Now, this is the objective that even the precursor RED 1 did not address or identify, which is the indirect land use change conversion and the related greenhouse gas emissions. So, and on this point specifically, when Malaysia contests that the objective that the EU is trying to address is not broadly environmental conservation, addressing greenhouse gases and climate change or biodiversity conservation. And of course, public morality was also one of the issues that EU raised, which the panel did not go into. But the panel technically goes into the specific objective that the measure was required to address, which is the ILUC related GHG emissions, and for which international standards also did not exist. Now, a large part of reliance by Malaysia was on the existing 4 international standards on life cycle assessment and carbon footprint assessment. And these standards to some extent were found relevant to the issue, but because they did not address this specific objective of ILUC related carbon footprint and life cycle assessment, the panel relied on the EU's approach, examined how the EU identified the specific objective going into the background of RED 1 and RED 2. And on that basis, the objective was found to meet the broader policy goals that the EU was claiming. So while holding that the EU cannot claim the entire EU biofuels regime's policy objective as the objective of the RED 2 also, on which Malaysia was contesting, the specific objective that Malaysia had identified was found to be correct, but only point that was further examined was whether EU's broader policy objective of climate change conservation was met or not. Now, with respect to going into the issues of TBT analysis, as Professor James also pointed out, there are a large part of the GAD analysis is found common and for reasons of judicial economy, which the panel does not cite overtly, but relying on the fact that a lot of arguments that Malaysia and EU had made were common to the 2 articles, the panel substantively dealt with all of the issues of likeness, substitutability, consumer preferences, even Article 20 issue of public policy legitimate objective under the TBT analysis itself. So 2 points here that I wanted to focus on was with respect to availability of reasonably available alternative. Now, Malaysia had identified at least 6 alternative measures that could have been there to address this specific tool. So again, the panel linked it with the objective of ILUC conversion. So some of the measures that Malaysia had identified was the EU deforestation regulation itself, not the first but perhaps the third or the fourth alternative. And also the fledgling regulation, which was a precursor where you could have bilateral arrangements between suppliers and or operators or traders in the EU. And amongst others, I think it had also identified one specific clause in the EFTA Indonesia trade agreement, where they had entered into a specific provision to ensure that the way palm oil exports were happening by Indonesia to the EU was happening through a specific contract where the traceability of the entire palm oil was sort of provided. But even at this level of standard and detail, the panel stated that this would not ultimately help the EU achieve its objective of ILUC conversion and saving of GHG emissions from those, and therefore these were found to be complementary alternatives, but not alternatives which would replace the entire regime. So that way I find the standard very high of having a reasonably available alternative, specifically when we see in the context of Article 20, that the panel specifically stated that only if a measure can be found to be redundant when you have an alternative, and that alternative makes the original measure redundant and almost fully replaces it in terms of result-orientedness and action, then only it can be said to be a reasonably available alternative. All the other measures, while contributing to the same cause, but because they are not addressing this ILUC-related emissions, they cannot be said to be reasonably available alternatives. So in objective, it makes sense, but with respect to the observation of a measure fully making the other measure redundant raises the bar too high for offering any possible alternative. So I feel that is somewhere where there's kind of a slight overreach by the panel in explaining what kind of an alternative it expects for a measure to not be found as necessary. And this was also what it resorted to in case of the Article 20 analysis. Now, the other interesting thing is EU had raised three broader policy goals, which is environment conservation, climate change, biodiversity conservation, and the third was public models. The panel, while going into the other two, biodiversity conservation, climate change, general environmental concerns, did not go into public models at all and stated that this was perhaps not necessary because the other two were found. But if you see it from a legal perspective, it also raises the question that if you find one goal to be addressed, which you're finding in positive, then perhaps you don't need to analyze even the second goal. So it did not even state it for the reasons of judicial economy that why it was not examining the public models objective. And why I state it is because a lot of EU measures inherently rely on climate change along with a lot of consumer preference, public morality concerns also. So that is somewhere the panel could have given more light on in terms of either why it was following a particular approach or why public morals examination was not important. It did not do that even in the TPT analysis under Article 2. So that was one other point that I wanted to highlight. Now when it comes to standards, of course, it gives a clear latitude that where there is absence of standards, countries can definitely regulate so long as they do it in a non-discriminatory manner. So that was kind of an expected outcome. But in terms of the length at which the panel has gone into to examine the existing standards, the EU's overall broader policy goals, the other regulations that were existing prior to this regulation, and Malaysia's claim of the regulation being protectionist. It does not really explain in that much detail in terms of the substitutability aspect. So obviously the panel relies in terms of the no less favorable treatment that competitive substitutability is what it actually relies on in making the claim under 3.4 as well as 2.1 of the TPT agreement. But in terms of the facts that it has examined, that could have been done in a greater detail, specifically when it also examined the physical properties of where the three biofuels and the related oil was coming from. So that is one place where you see a lot of analysis of facts, but in terms of the legal findings, it's rather what is expected and a little focus towards the language of the provisions itself without examining what the facts interplay and inform that. So, and the other last point that I wanted to mention was with respect to the issue of consumer preferences. So that is an interesting area of inquiry in terms of even other EU regulations, because a large part of regulations is what determines and drives consumption now in the EU. So a lot of sustainable consumption is now now not being driven because consumers prefer it or are cautious of it. And as Professor James also said, that if you were to use a fuel, you really don't know where and don't care a lot of times practically where its composition comes from. And this is specifically true when it's a blended fuel or where consumers may not reasonably be aware of where a specific product is coming from, except for maybe greater and graver concerns of environment, animal cruelty, and so on. So with respect to consumer preferences, I think the panel makes a clear but a brief intervention that consumer preferences do not determine the demand in the EU market. In fact, the market itself is created by the RED II directive for advanced biofuels, and therefore consumer preferences also don't help in determining likeness. And this is going to inform a lot of other EU regulations, maybe to a greater or a lesser extent. But this is a very important factor in assessing likeness, where EU regulations clearly fall short of, because consumers a lot of times are unaware of what the regulation is oriented towards. So that was my last point. Now with respect to the similarities and differences that arise for future regulations. So deforestation regulation is of course one important regulation. Deforestation regulation of course prohibits products that have contributed to deforestation or forest degradation from being placed in the market. So that way I think quantitative restriction analysis will be more deeper with respect to the EU deforestation regulation. Whereas in case of this regulation, the panel clearly found that this was not a measure that was directed or related to importation or was on importation, so therefore Article 11 was overruled. So that is one area where the facts will differ. The second is to some extent consumer preferences also, because if consumers are progressively made aware of something causing deforestation overtly, that may differ from when you use diesel fuel or blends of fuel where you don't really know and possibly cannot know where a specific component is coming from. So that way I think a lot of details lie in the facts and composition of the measure, and that is where differences will also lie. And with respect to Article 20, of course the analysis is not that deep, it's a little general in terms, but it was also because the panel found it to be discriminatory and disguised restriction, because the data for other crop fuels was not adequate that the EU considered. So with that, I would conclude. Thank you.
The report itself, there are not many points in this with respect to TBT, SCM, GAT, and Professor James has comprehensively covered those points. Shri Pradeep has offered all the insightful points. Dr. Anwar has stated the environmental concerns. I would like to touch on the issues maybe which are do not seem per se important but are practically very important, is that the transparency obligation. Considering the party which is involved over here, it's EU, which claims to be the flag bearer of transparency. And the transparency obligation has been decided on 2 counts for 2.9 and 5.6. These are the articles of the TBT agreement dealing with technical regulation and conformity assessment respectively. On both these counts, it has been found that the EU's measure was inconsistent with transparency. If we look at 2.9, it clearly says that when a party is departing from international trade standards, which has been clearly read by the panel and over here also by the panelists, that there was a departure with international standards. There were 4 ISO international standards which were compared with, but it was found that they were not fulfilling the objective as per EU. That is why it was stated that EU was okay in, they were correct in following their own standards. This fulfills the first requirement of 2.9, which is when there is a departure from international standards. The second requirement of 2.9 is if there is an impact on the, if there is significant impact on the other trading partner, which is also proved by the panel in their own discussion. Now when these 2 points are fulfilled, it becomes obligatory on the members to notify this technical regulation as per 2.9 process. And the process itself is laid out in 4 pointers. First of all, the draft measure, that is, it's not the final measure. The draft measure needs to be notified to the TBT committee so that the WTO members are able to hold a discussion or a consultation on that point. 60 days of comment period is to be provided as per the TBT committee guidelines. Now, all these were omitted with because EU took a stand that it is not a technical regulation. And interestingly, this stance of EU is being observed in Eco-Design for Sustainable Product Regulation, ESPR, and very importantly in the EUDR. There is a very common similarity between EUDR and what India is also one of the first parties under leadership of Nitin Sir that we have been raising EUDR issue as a STC in WTO. There is a constant submission of EU since last year June to this year June that EUDR is not a technical regulation. So again, on the same parameter, they have omitted the obligation of 2.9 and 5.6, which is to provide 60-day comment period on a draft notification and the comments are made by trading partners which are to be considered, and post that there is a reasonable interval which is called 6-month interval period to be provided so that parties can apply or so that EU can then implement the provision, parties can get the reasonable time to comply with it. However, this entire obligation is again and again being deflated by European Union by stating that it is not a technical regulation. Now, interestingly, even if a party says it is not a technical regulation, there could be another way to fulfill the transparency criteria. And the answer to this question also comes from EU's practice. If we look at the notification of waste shipment regulation, this has been done very strategically by EU in the TBT committee. They have put a note on this notification where they have stated that they are not prejudging whether the measure falls as a TBT measure or not, but they are notifying the particular measure in the committee for the sake of transparency. However, this act was not done for the red measures or is done for EUDR until date, or not is likely to be done, or is done for CBAM, or is not likely to be seen to be done for ESPR. China has also started to raise the ESPR issue as a STC in the WTO committee. Another interesting point which I see in this is that the dissenting or the separate opinion clearly mentions, sorry, before that I forget, there's another important point with respect to transparency obligation in the panel report. It has been stated as that the publication of the measure must be done through the Secretariat in the TBT committee. If the publication is done in your own national website, that does not amount to fulfillment of the obligation. Further, the panel also goes on to the level to appreciate the evidence that the publication of the measure was not available on the e-ping tool which has been created for the TBT and SDS measures. This tool has been taken into account as evidence. So, Malaysia presented that they were not able to find the measure within the tool, and that is why it was declared to be inconsistent. The other point regarding the dissenting and separate opinion is that regarding Article 2.2 of the TBT, which says that there needs to be a legitimate objective to fulfill it. The separate opinion specifically mentions many studies, of course. 7 out of 9 studies have said to be declaring that there is no certainty that palm oil is creating more environmental footprint. But there is specific reference to the EU's parliament, where the parliament has stated that there is no certainty, and it has also stated that the soybean or the rapeseed oil may have more impact or more environmental impact than palm oil. So this is another interesting point in this. And what I see for those who may not have the time to read 350 pages of the report, there is a paper by Josephine Norris, who is a legal service official of European Union. She has consolidated the entire discussion in 30 odd pages. But there is something I don't find in that report as well, is that the discussion of SNDT principles, which is with respect to Article 20.3. Now, recently, I got this opportunity along with Nitin sir. Under a negotiation, we were discussing the point of taking into account. So, taking into account is a principle embedded in 12.3, is that the developed country members need to take into account the comments of the developing country members. However, the panel has decided it as probably in terms of plain reading of the provision, which doesn't seem to be wrong, but I have a personal different view to this. because my issue comes with, even though it is proof that EU is inconsistent with the 2.9, 5.6 transparency obligation, the inconsistency remains toothless because there is no repercussion to that. If we have to, if the panel clearly says that it cannot be legally said that the provision has been, that the measure has been notified to the other country. If it has not been notified, then how can you consider the comments of the measure to be taken into account? However, the panel has taken the view that even though it was not notified, EU and Malaysia and Indonesia had correspondences via letter exchanges on the sidelines, and those were considered to be taken into account. So I see it in a different perspective. But of course, the panel has ruled that way. And so of course, these are certain issues in addition to what has been highlighted. But what I see in future is for EUDR, in my own reading, is that it's very likely to be proved as a technical regulation, and then there will be a violation of transparency, and probably it will remain toothless. But another point about the 2.1 TBT obligation is, which has been held by the panel, is that, which is interesting to note, that the EU relied on a data covered from 2008 to 2016, and the measure came in 2019. Even then, the panel has ruled that the data was not contemporary. So when, and the panel has specifically recorded that when a measure is heavily based on data, it must be relied on contemporary data. And the second measure, where there is an option given by EU to take into account, to opt for the criteria of low indirect land use change criteria. If you want to opt for this criteria, the option is given, but the implementing regulation remains vague. And because it is vague, it is not possible to be complied with. And therefore, the other important point falls in this category is that one is not, even though the option is given on paper, but one is not able to comply with because it's not practically possible. So these points are very important for future consideration. If there is going to be a measure, if it is not updated in data, and if it lacks clear implementation guidelines, it is very likely to be held inconsistent. So thank you very much.
My question is to Professor James, and it's particularly regarded to the unlikeness analysis, may that be under the TBT or the GAP. You rightly mentioned that the EC asbestos case is very relevant over here with regards to NPR PPMs. However, in the EC asbestos case, the asbestos was present in the products itself. And therefore, while they did say that they were unlike, the appellate court did say that it was unlike because of health risks, it is differentiated from this case because the carbon emissions or the carbon impact is not present in the products itself. So do you believe that we can stretch the logic of EC asbestos to also cover NPR BPM?
And one of the things that came to me across my mind was the fact that EU is using public models exception to justify these measures. I would just like to ask you as to your point of view, because public models is quite a vague and open-ended exception. And can it be used for climate change measures?
Okay.
It's only one part of it is found to be inconsistent. So my next question is, if that is so, then how do we see, whether other panelists also touched upon other regulations of EU, how that interpretation is going to play along? I know part of it has already been answered by the discussions, but I would like to see how CBAM and EU deforestation regulation in particular, which is now a very hot topic, and this decision will overplay, because only a part of it is found inconsistent and other measures are found to be not inconsistent. In fact, if we see the summary of the WTO Secretariat report, a lot of it seems like it's a positive for EU, but only when you read it very carefully you find that it is not EU positive. It is actually a benefit for the Malaysia, and they had successfully defended the case. But how do we see in the interpretation of the panel and the other regulations as well? Thank you.
border tax adjustment criteria. So the first thing is actually physical characteristics, nature and properties. So your point that in the AC asbestos case, the two products were entirely different products. So the panel actually made a mistake. The panel said that both the products are actually like products. So without going into the difference in physical characteristics and other things. So what the appellate board said is that, is not clear? So what the appellate board said is that the panel actually made by intertwining the analysis in the first two elements of the border tax adjustment in the AC asbestos case. But here we are looking at the third criterion, which is the consumer perceptions thing. So on the consumer perception thing, again in the AC asbestos, the crescentile fiber was actually creating some kind of a health risk in the minds of people. And what the panel said is that when it interprets the likeness, they will have to actually bring in the element of the tenant, the health risk involved in the product as well. So similarly, this panel would also have taken into account maybe whether the consumers actually perceive, palm oil based biofuel and rapeseed based biofuel as like products based upon the greenhouse, the climate change risk involved. So anyway, I think there wasn't much of a discussion. Maybe the evidence wasn't there. Other than that, I think if you read the panel report also, the appellate board report in AC asbestos, whether non-product related will come in, I think, what was actually the second thing? So regarding Krishna's point, maybe I should give the opportunity.
0.5 degrees Celsius, 2 degrees, then now 1 point. And climate emergency, that's the vocabulary they have been, that's a change, it's emergency, it's urgency. So accordingly there, that they, if you see the kind of network and you read the children, women, youth, and they are bringing climate change mitigations in the domestic setting, condition level of greenhouse gas emissions. You see, yes, it affects our life. So the duty of care element is that they figure in prominently. So this is how I address and if you read some of the judgments in Court of Justice of European Union also, I think James will better address, can clarify that way. Court of Justice of European Union, in aviation case, it said that our those flights which are landing in Europe, so they will have to carry the allowance, all the carbon allowance. So this is not something internal thing that the internal tax or something like that. It depends on demand and supply. Since you are in our territory, so you have to follow this. Okay. So there you see that even the European Court of Human Rights judgment also, if you read it, they say that the climate change affects our family life. Once there is a flood and the people are dislocated, isn't it? Your daughter, children are like here, there, you don't know. It is serious dislocation. Public itself, I do not remember exactly the name of the case. If you read European Human Rights judgments, very famous judgment. The public is Article 2 and 8 of European Convention on Human Rights. If you see it from this angle. Okay. Thank you.
Just want to mention it. So in some of the cases that came up before the WTO, most importantly, the AC seals case, the public models. Generally, it is accepted because it is quite difficult. Unlike all of the elements of Article 20, it is quite difficult to actually find out whether this is not a matter of public model or a matter of public model. So there is a certain element of, I think, self-judging nature to that exception. One point which Shri pointed out, just want to mention here. So this is almost like throwing in the kitchen sink argument, right? When you come up with any kind of a case, you will bring in all kinds of arguments, and generally this will be a last argument. So that is, I think that may be the reason panel did not even touch upon that issue, because that is quite difficult to make a judicial interpretation of what is actually a public norm exception. But anyway, Malaysia, sorry, European Union is pretty happy that their two defenses were accepted, Article 20G and 20B. So they don't have to necessarily go to Article 20A as an additional layer of protection. But so the point is, there have been few cases. One interesting case is actually the Brazil taxation case, where in order to create this kind of infrastructure, public infrastructure for IT-related services, they claim the public norm exception. So the point is that this is something very interesting. When India had actually a case called the India Solar case, and that case was again taken for meeting India's renewable energy objectives. We used Article 20J on the GATT. At that time, nobody thought that Article 20A can ever be used. So there has been a bit of evolution in the last maybe 1 decade with respect to the use of this exception. But anyway, I would still say that these are uncharted territories. One shouldn't use it, otherwise they will lose the need.
Agree with that, because I think it comes down the way the case is structured and how the panel has gone into obviously a lot of TPT claims because they were raised and validly raised. So on notification, consultation and transparency, they clearly state that EU has fallen short, which is to some extent surprising because a lot of times their consultations are very detailed for other regulations. But when we see with respect to even Article 3, 4 and 2.1, I mean it's a clear-cut case where the discrimination angle and in fact de facto discrimination has been upheld by the panel. So that way it's a clear win for Malaysia, but I think it's only that the way the panel has given its findings after examining the fact does not states it in a very plain factual manner instead of clearly specifying why EU has fallen short of some things, but just factually stating that they considered only oil palm and not soy and rapeseed crops also falling within that, and how they fell short of that has not been elaborated upon in that detail. So that is one of the reasons why it does not appear to be that much of a win for Malaysia. So if Vishishth wants to add anything or so.
I just want to add one more point. So this case is actually, as lawyers call a realist case, realist court. Ultimately, who won the case? The European Union. I mean, but if you really look at the, take a look at all the claims Malaysia has won, they have won a number of claims actually. So that's why if you want to win a case, bring in TGT claims. There will be multiple areas, as my colleague mentioned, Vishishth mentioned. On multiple areas, you can actually bring in some violation of the TGT again, either a notification or a reasonable interval. There was actually another article, Article 5.1, conforming justice. So it is actually interesting, but substantively speaking, the European Union's objective to meet the climate mitigation goals has been accepted. What they said is that you should have taken these kind of evidences into account. So there is a danger, I think, if you go and challenge some of these cases, you may win a few things, but you may also lose it.
Very interesting point, but I would like to highlight another nuance to it and probably look a bit back from a top level. And if you see the strategies, EU has been very steadfast in saying that all these measures are not TVT measures. And it realizes that it will be caught up in the details. Because implementation is always, as was mentioned, that we can, all countries, because there's so many countries, practically the whole tropical area, countries would be affected by these climate change measures, and EU is out of it. So purely by the geographical location, the impacts are different. So to that extent, they do realize this point, and that is why they have been so steadfast in not getting into this TBT regime. Now, what is the strategy for us? So being a tropical country, practically the global south and most of the countries who are affected, it would be important that we take away from this case that yes, it is all these measures, similar measures should be treated as TBT measures. One. Second is that earlier we used to take up a stance which was probably reflected in a panelist's point, that these are environmental issues and there are different forums for it. We have Kyoto Protocol, we have other environmental related negotiation and agreements going on, how would those be playing vis-a-vis the trade agreements? So both the international environmental laws and international trade laws should some way harmonize, and that aspect we seem to be losing. So now the environmental measures are being treated as legitimate trade, so you can have environmental objectives being achieved from a trade law. So there is some win, there is some lose from our original stand. So to that extent, we need to probably change our strategy. We keep fighting our original, point that these two are different subjects and to be treated under different laws and different agreements. But if things change, and it is changing, we need to now look into more depth of how the implementation is done, and how the objective is not trade discriminatory, and cause of discrimination between the countries, and especially, as I mentioned, the geographical location. The impact is naturally different. So to that extent, can SNDT principles and all those can be straight away disregarded, has to be also understood.
Maybe Vishishth, or you can conclude because we will chair. I think we don't have. So if there is no other question, then we have another book as well.